Good afternoon, and a very decidedly not stupid o'clock, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels, and we're going to have a few vids today. But we're going to start it off as we do every day. That horrible world known as the JRC. Yes, that's right, folks. We are taking a look at the attempt to vacate the consent decree from 1988. This was back from February of 2013. If anyone wants any indication of just how long we've been fighting these people, it's literally been that long. And this is just the one of many attempts to get rid of that outdated, disgusting consent decree that the JRC uses to continue to abuse and torture people with disabilities with impunity, and that the Court of Massachusetts continues to use to protect them. Now, before we get started, the usual disclaimers. First off, you are going to see a link to these legal documents right there in the description box, as well as the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive, where we have our source on this channel for the majority of these videos. She has a massive archive she's compiled for years. Please take a look, share everything you find on there. Also included is the ever-present templates. Folks, we have been fighting for years to end adversive therapies and improper restraints, especially in schools. These cause deaths, folks, every single year. So, folks, please take 2 minutes out of your day, type your name, click on your senator. It takes less than 2 minutes. The wonderful people at ASAN has gone out of the way to make this as easy as possible. So please make sure to go over there, use these links, sign these petitions, okay? All right. Also, we have the ever-present change.org Shut the Judge Rotenberg Center Down petition, whose name is self-explanatory. We're tired, folks. We've been fighting these people for over 30 years, some of us, to hold these people accountable and get this place closed down so that these students can be safe. We, at this point, do not see any other way around it. We have tried every other way that has been available to us. The only way we see the students currently in there and future students, the only way we can keep them safe is by getting this place closed down and getting those students to places that will actually help them as opposed to torture them. So please sign it and share on all your social media accounts. Also, folks, when we are talking about the JRC, trigger warning, you're going to hear vivid descriptions of, as well as sometimes catch clips of surveillance footage of, peoples with disabilities being tortured and abused. If you have young children present, please, folks, please use your headphones. Also, folks, we all know these documents get me all kinds of agitated. So if I just run off into explicitives, that will make a sailor blush, or go on to run-on sentences, or stumble over my words. My apologies in advance to you all. So, folks, we are going to where we left off yesterday, the consent decree and the extension order. We're about to find out how it was that the JRC has managed to use a ruling that was only supposed to last a year and extend it into infinity. This is going to be something that's going to be rather helpful in helping us understand why this place has been so protected. So, let's take a look here. Also, it goes without saying, have your calm down tea. In June 1986, this court, Rotenberg J., entered a preliminary injunction barring enforcement of OFC's orders, finding that the director of the OFC had engaged in bad faith regulation of JRC and that her termination of the JRC's treatment procedures was without medical support. Really? Do I need the doctor to know that using pneumonia on vulnerable people, pinching them, giving them hard muscle pinches, slapping them, and spanking them is abuse? Pretty sure I don't need a medical degree for that. Just saying. A few months later, the parties entered into a settlement agreement, which the judge approved on January the 7th, 1987, and incorporated as an order of the court. The agreement's core provision, Part A, provides that aversive procedures are permitted for use at JRC only when authorized as part of a court-ordered substituted judgment treatment plan for the individual client. Yeah, we all see how well that protects the students, right? Settlement agreement and order attached as EXH2 to Hale's official decree. Part B provides in turn that on the occasions when the court issues a substituted judgment treatment plan, the court shall also appoint a monitor who will report to the court, which does, again, nothing to protect the kids. So, yeah. The monitor is not only empowered to oversee issues regarding individual plans, but also has the general authority to oversee JRC's treatment and educational programs. In addition, if any disputes arise under the agreement, the parties must bring them to the monitor for arbitration. By its terms, the agreement was made for this case only, and for the sole intent of each party was simply to resolve this case and the other administrative judicial cases which were then pending between OFC and the parents. Consistent with limited intent, Part K on the agreement provides for termination after approximately 1 year. I'm sorry, when you're a parent and you're defending a school that is causing your kid, because they are disabled, to be smacked, hit with spatulas, had ammonia used on them, allows people to force strain, bind them, and then generally abuse them. Yeah, you shouldn't be a parent. Just putting it out there. The probate court shall conduct a hearing at 6 months intervals in order to review the parties' adherence to the provisions of this agreement. This agreement shall be automatically extended to the first 6 months review unless the court, upon motion by any party, orders otherwise. This agreement shall automatically terminate at the second review unless the court, for good cause shown related to the terms or substance of this agreement, orders otherwise. And why did they order otherwise? And who lined their pockets? That's what I would be interested in finding out. Likewise, the agreement provides that the term of the court monitor shall be for a period of 6 months, unless extended by the court in accordance with the provisions of paragraph K. In July 1988, after the second 6-month review, this court, Rotenberg J., extended the agreement until further order, which is insane. Insane! This was supposed to be about one case, and they have used it to extend into infinity as an excuse, a reason, and complete legal consent and cooperation for this place to continue to torture people. It's insane. And get state money to do so. And federal. Just saying. The sole reason for the extension was that, at the time of the hearing, JRC was not fully licensed. Order July 7, 1988. The contempt proceedings and receivership. In the mid-1990s, JRC brought a contempt action against DMR, claiming that it had violated the consent decree by refusing in bad faith to grant JRC's request for recertification to use Level 3 aversive interventions. Is that a fact? because you all were not using the same types of aversives. You introduced electric shock. Seriously? Among other things, JRC alleged that DMR, acting under the direction of the Commissioner, had refused to arbitrate disputes as required by the decree, attempted to disrupt the JRC's relationships with funding agencies and clients, and directly contradicted outstanding court orders by conditioning JRC's recertification on its agreement to stop using certain aversive procedures. You mean they told you to stop torturing people or they're going to yank your license? You see, out here in Missouri, our DMH out here, they have the full authority to be able to do that. Yeah, we find you torture somebody and you're a facility, guess what's going to happen? And I'm in the Bible Belt. God. Massachusetts, you should truly be ashamed of yourselves. This court found DMR in contempt and, as a result, issued an order incorporating the consent decree and appointing a receiver to manage the agency and all its relationships with the JRC. See what I mean when I say this state and its courts bend over backwards to protect these bastards? And anytime, any goddamn time, anybody raises any questions, they use those courts who have been protecting them for years to slam them down. It's insane. It's insane. The receivership was in place from 1996 to April 2006, during which time DMR fully cooperated with the receiver in issuing licenses and certifications to JRC. Affidavit of Elin M. Howe. This included JRC's Level 3 Aversives Intervention Program, which should be fucking banned from the planet, which was certified several times after review by various DMR Level 3 certification teams. There should be no Level 3 Aversives. You shouldn't be using Aversives, period. In the year 2021, when are we going to stop punishing disabled people for being disabled? That's what I would like to know. In addition, DMR's commissioner and senior staff met quarterly with the receiver and JRC's representatives to resolve any disputes concerning JRC's programs. Y'all should be closed down and put behind fucking bars. In 2003, based on DMR's compliance with the receivership order, the receiver submitted a report opening that the relief ordered by the judgment and order has been accomplished. Special report of receiver, we plan for winding down the receivership May 19, 2003. The receiver thus recommended return of regulatory authority to DMR, followed by transfer to the Office of Child Care Services, OCCS, of authority to license JRC's programs for children. They shouldn't be anywhere near children. Notably, although JRC objected to OCCS's assuming license authority, the receiver rejected those objections on grounds that they were based on historic concerns arising from the actions of OFC, which could not be attributed to its successor agency. More than 16 years have passed since the Judge Rotenberg approved the terms of the settlement agreement between JRC and OFC. Since that time, a new agency, DMR, was constituted, and OFC was reconstituted into today's OCCS. Agency regulations have changed, as has commissioners and staff. The actions of the OFC in the 1980s, however improper, should not forever preclude OCCS from licensing JRC's programs. In September 2003, many regulatory functions were returned to DMR, pursuant to an order entered by this court. Behavioral Research Institute versus Philip Campbell, Order of Bristol County Probate Court. Then in April 2006, after a decade, the receivership was formally terminated. Behavioral Research Institute versus Philip Campbell, Order of Bristol Court Probate Court, April 16, 2006. Current factual situation. Defendant's compliance with decree. In over 6 years since the receivership ended, the Commonwealth agencies have consistently complied with their obligation under the decree. Under termination of receivership, all administrative and regulatory functions were returned to DMR, and then its successor, DDS. These functions have included certifying and licensing programs for adults with intellectual and developmental disability, granting approved to occupy and licensing residences occupied by adults with intellectual and developmental disability, investigating and disposing of dispute abuse complaints. Again, why do they dispose of these complaints, folks? Because it's people with disabilities making them. And you know what they say in Massachusetts, if the courts say it's okay, then it's stellar. God. Y'all really haven't improved since Salem, have you? Appointing the independent clinicians to review court-approved treatment plans, developing individual support plans, reviewing proposals and contracts between DDS and JRC, and reviewing restraint forms. And doing nothing different, I might add. Since 2006, DDS has regulated JRC in a transparent manner in all these areas. Transparent, my ass. The JRC has never been transparent. It has granted licenses to JRC to operate its residences and day programs, investigated complaints of abuse with impartiality. My ass! My ass! Explain Andre McCollins. Explain that shit to me. Jennifer Masumba. Tori Amos. What about the 6 deaths that you all like to continue to make excuses for? My ass. Monitored restraint use. Certified JRC's Level 3 program based on comprehensive and impartial review by a team of experts. Bullshit! Then why is it not recognized in any other state but yours, Massachusetts? Missouri's not doing that shit. Not even Arkansas is doing that shit. You all want to cry against Republicans, and yet at the same time, by those states that are mainly run by Republicans even, and the most progressive states, that shit's not allowed. Explain that to me. So-called progressive state, my ass. And when necessary, engaged in arbitration before the court monitor, thus in stark contrast to the conduct of the OFC that led to the filing of this case in the 1980s. DDS has worked with JRC to license and regulate its programs with transparency and compliance with the decree, but not for the safety of the students. Told you I'd curse. Professional consensus opposing the types of aversive interventions currently used by the JRC. Thank you, Jesus. Now some sense. The types of aversive interventions used at JRC have changed significantly since this action was filed over 25 years ago. Now, JRC's primary technique is the graduated electronic decelerator, GED, or contingent skin shock, which is torture, which is used to administer an electric skin shock when a client engages in maladaptive behavior. You know, like cursing, like I do. Or doing this, stopping work for 5 minutes, blinking excessively, making a noise even when, in fact, it is coming due to the student being sick. The list goes on. The GED is more recent intervention that was not in use in the 1980s and is deemed a Level 3 aversive under DDS regulations. To include blah, 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 blah. Intervention which involves the contingent application of physical contact, aversive stimuli, such as contingent skin shock. And you all still can't explain to me this day the logic behind, oh, they're hurting themselves. We have to stop them, so let's hurt them. Anybody? Anybody see the logic in that? Contrary to JRC's practices, the overwhelming weight of professional opinion opposes the use of Level 3 interventions such as the GED. Thank you. Dr. Gary Lavinia, Clinical Director of the Institute for Applied Behavioral Analysis in Los Angeles. Boo! Boo! Yes, let's use behavioral modification techniques to treat autistic people who have a neurological disorder. States that since 1985, clinical and empirical research has developed such that there is now a consensus professional opinion that positive behavioral supports PBS, applied behavioral analysis without punishment, can be used to effectively treat people with challenging behaviors. I'll give you challenging. Affidavit of Dr. Gary Lavinia. While PBS was still in its infancy in the mid-1980s, numerous studies over the past 25 years have established its effectiveness, even in a case where punishment has failed. Oh, you mean that it's taught people like me to mask our entire lives, and when we have a meltdown, everybody is shocked. Thus, given the ethical principle and legal requirements that treatment must be accomplished by the least restrictive means possible, and in contrast to the professional opinion that may have prevailed when the decree was entered in the 1980s, the current consensus is that the punitive procedures are professionally unnecessary and inappropriate and not ethical. Thank you. Instead, PBS has reached a point where it is generally accepted standard of care in the relevant treatment community. Without our input, of course. With respect to the contingent skin shock specifically, given its severity, there is near universal agreement that it is professionally unnecessary and inappropriate because there are other far less restrictive methods available to treat challenging behaviors. Lavinia, Affidavit 15. Dr. Lavinia describes contingent skin shock as much more intrusive and restrictive intervention than any of the aversive procedures listed in the complaint or in the decree. Water sprays, taste aversive, muscle squeezes, spanks, pinches, and restrained time out. Dr. Lavinia opinions are consistent with the position statements of virtually every major professional and advocacy organization for disability rights. Thank you! For example, the American Association on Intellectual and Developmental Disabilities, AAIDD, a leading national professional organization, has stated that research indicates that aversive procedures such as deprivation, like, food, physical restraint, and seclusion, do not reduce challenging behaviors and, in fact, inhibit the development of appropriate skills and behaviors. Yes! Oh my God! Say it louder for the people in the back. That's so good I have to read it again. Alright. Let's say it again. Research indicates that aversive procedures such as food deprivation, physical restraint, and seclusion do not, hear that now, hear it, do not reduce, challenging behaviors, and in fact inhibit development of appropriate skills and behaviors. Thank you. These practices are dangerous, dehumanizing, result in loss of dignity, and unacceptable in a civilized society. Oh my God, this is so good it must be fattening. Let's say it again. These practices are dangerous, dehumanizing, result in loss of dignity, and are unacceptable in a civilized society. The MA chapter of the AAIDD and the Region 10 Board of AAID fully support efforts to eradicate aversives from future behavioral plans. Thank you. The ARC, a national advocacy organization. And the ARC, by the way, folks, is also a national organization that provides services to those with developmental disabilities. I know. I used to have some of their services as part of my person centered planning. The ARC, a national advocacy organization, has also issued a position statement in favor of using PBS for treatment of individuals with intellectual and developmental disability. Similarly, TASH, under National Advocacy Organization, has concluded that although it has been believed that aversive procedures are necessary to control dangerous or disruptive behavior, it has now been irrefutably proven that a wide range of methods are available that are not only more effective in managing dangerous and disruptive behaviors, but do not inflict pain on, humiliate, dehumanize, or overly control or manipulate individuals with disabilities. Therefore, Tash affirms that the right of all persons with disability to freedom from overly restrictive procedures and from aversive or coercive procedures of any kind. Tash is unequivocally opposed to the inappropriate use of restraint and to the use of overly repetitive and aversive procedures under any circumstances, and calls for the cessation for the use of all such procedures. Preach! Moreover, numerous settlement agreements and remedies obtained by the U.S. Department of Justice (DOJ) in major civil rights cases regarding systems of care for persons with intellectual and developmental disabilities reflect an emphasis on PBS and prohibitions on aversive interventions. And a similar result was reached in recent federal class action against the Minnesota Department of Human Services, in which the parties entered into a settlement agreement that prohibited the use of aversives for persons in the state's care and established a statewide acceptance of positive behavioral supports. Finally, these standards are reflected in the laws and practices of the majority of other states. DDS is unaware of any other state that has authorized the use of aversives such as contingent skin shock. Further, 21 states affirmatively banned aversives through the statute, regulation, or policy, and many others have banned their use in practice, like Missouri. This includes New York, which has placed students at JRC as authorized by that state's law. Bryant versus New York State Education Department, 692 F3 202 208. In 2006, New York's education agency repudiated the practices used by the JRC by proclaiming a regulation prohibiting schools, including approved out-of-state day or residential schools such as JRC, from using aversive interventions. That regulation was recently upheld by the Second Circuit against a challenge under the Individuals with Disabilities Education Act, the IDEA, folks. This is why you should learn it. This is why you should love it. The Rehabilitation Act and the federal and the New York constitutions. All right, folks. So, what did we learn from this little episode here? They are stating that these methods are outdated, do absolutely nothing to what the JRC says that they do, and are actually dangerous. This is a agreement that should have been done and over with a long time ago and should not be used after 30 years on to continue to justify the abuse and torture with people with disabilities. When you have people who believe in ABA and masking, who actually agree with us on this one, school, that should tell you something. That should really tell you something. And on that note, And on a jubilant note, seeing that for once in our entire review of all these articles that somebody has some goddamn sense, we're going to go ahead and close out for this morning and get ready for our next video here. We don't get very many views on this channel, especially on this subject. The few that we do get do tend to get removed from time to time. But folks, please don't forget to hit that like button, hit subscribe, don't forget to hit the comments, and feed that algorithm. I do appreciate your time this afternoon, and as always, we here at Spilling Tea hope you have a good one. Till the next vid.